Hey guys, welcome to our video. This is John Watts. I'm a consumer protection attorney, and I want us to go through a case decision from a couple months back. And this involves back taxes, IRS taxes. And what I have listed here is really the lesson of this case. So let me give you a little bit of context. So if you owe, let's say, $100,000 to the IRS and you're able to settle that with what's called an offer in compromise, maybe you pay $20,000. So you saved $80,000. That's fantastic. But here's the critical part. When you do that, you must stay in compliance with filing and paying your taxes for the next 5 years. If you miss filing your taxes, or if you don't pay your taxes anytime in the next 5 years, that settlement, in our example, $20,000 that you paid on $100,000 that you owed, that settlement's void, and the IRS says, all right, give us our $80,000 that you owe us. Okay, so it's different than say you're settling a credit card debt and they say, hey, you owe $5,000, pay us $3,000 and you're done. Once you pay it, you're done. But that's not the case with the IRS. You must stay in compliance. And I can't tell you how many people they're dealing with just crushing IRS debt. And unlike most folks, they actually make it through the collection process and they do the correct steps. They present a valid, legitimate offer in compromise that can be accepted. It is accepted. And then they pay, and then they blow it by not staying in compliance. And so let's take a look at this case. So Fifth Circuit Court of Appeals, July 7, 2020. So we have here an offer in compromise agreement. And in the kind of light red or whatever color this is, I've tried to use that every time it talks about you must be in compliance for the next 5 years. But the taxpayers did not remain current. And so the IRS issued a notice of intent to levy. That's where they're saying we're going to seize bank accounts or your wages. And it's incredible the percentage that they can take of your wages. We'll cover that in another video. And they also issued notice of your right to a hearing for the tax years 2008, 9, 10, 11, and 2015. So then the petitioners, and this is the right way to do it, because so many people miss this, they timely file for a collection due process, a CDP hearing. And the officer there determined the IRS recovered the right to collect the uncompromised balances on the 08 and 09 liabilities. And this is true even though the taxpayers had paid the agreed amount under the offer in compromise. But look, they failed to comply with the payment requirements for the next 5 years. And so the taxpayer said, how about we pay you $350 a month? And the IRS settlement officer said, nope, I'm not going to do that. I'm going to levy on you. Tax court sustained the determination, so they appealed the tax court's judgment to the Fifth Circuit. Fifth Circuit said, we completely agree with what the tax court did. So let's go back and get a little more detail on the facts. I'll say this, some of the numbers don't exactly make sense here, so we're not going to get bogged down into figuring out the exact numbers. I want us to get the principal lesson from this, which is if we have an offer in compromise, first of all, don't request it if we don't think we're going to get it, and don't request it if we don't think we're going to stay in compliance. So here they timely filed their tax returns, which is fantastic. A lot of people that ask for help with this, they haven't filed tax returns for 3, 4, 5 years, but these folks had. So they filed 08, 9, 10, 11, and 15. Although they reported some tax owed, they did not enclose the payments, and then the IRS said, actually, you underreported the taxes you owed. So it ended up being a pretty sizable amount, maybe in the $30,000 range. And so then they do an installment agreement for those couple of tax years that were at issue. And so they pay some money, and then ultimately, and this is not real common despite all the commercials about, we guarantee we can settle your taxes for pennies on the dollar. It's true, that is possible. It's just not real common. But look what happened here. April 2013, they entered into an offer in compromise. IRS agreed to accept $21,000 in full satisfaction. But here's the deal. Taxpayers have to comply with tax filing and payment obligations for the next 5 years. So this is just a standard form here that, well, for some reason I'm having trouble getting that highlighted here. So this is what you will almost always see, okay? And here's some of the language. I must comply with future tax obligations. I remain liable for the full amount until all terms and conditions have been met. I will file tax returns and pay required taxes for a 5-year period, beginning with the date of acceptance of this offer. So it's not when you made the offer, it's when the IRS accepts it. I understand what will happen if I fail to meet terms of my offer. If I fail to meet any of the terms, IRS may levy or sue me. A lot of people don't think about that, but the IRS can sue you for back taxes. So it may levy or sue me to collect any amount from the unpaid balance. And so in 2016, they evidently got an extension on it. They filed their 2015 tax return, but they did not pay the taxes. Well, the problem is that means they failed to remain current on their tax payment obligations, so the IRS said, you're in default. Now, will they always do this? They may not always do it, but it certainly is possible that even though you file a tax return, a couple years after you pay the offer in compromise, but if you don't include your taxes, then they could say you're in default to that offer in compromise. So what does the IRS do? This is 2017. They issue the Notice of Intent to Levy, Notice Your Right to a Hearing for these years, 08, 9, 10, 11, 15. And the petitioners, again, great job. They timely filed for a CDP, Collection Due Process Hearing. And so that was held by phone. And the officer said, well, you did pay the amount, okay? Every dollar that you agreed to pay, you pay, but you did not remain in compliance with the paying requirement for the next 5 years, and that means the IRS would bring back all of the liabilities. So they say, hey, we'll pay you $350. She declines, and she says, you know what, I'm going to levy you because guess what? You have a disposable monthly income of $6,400. Okay, so this is different than a typical wage garnishment if you have a judgment where they'll take a percentage. Here the IRS is looking to say, well, here's how much is exempt, and then we're going to take either all the rest or a good chunk of the rest. So the petitioners appealed to tax court, and they said, hey, look, that settlement officer at the IRS failed to consider we already paid actually more than we had promised to pay. And the agreement did not state compliance is required after the balance is paid. And the tax court said, nope, we don't agree with that. And so now the taxpayers are appealing that, and they say, look, we complied with all the terms because we paid it. Like once you pay it, it shouldn't matter what we do after that. Now this is weird, okay? This next part. They also argued that they would have arranged to pay the balance owed if the offer in compromise form properly informed them of the consequences. I understand why they're making that argument. It's just sort of an odd argument when you're saying to somebody, I could have paid you, and I would have paid you had I known it was serious, but I didn't think it was very serious. You got to be right if you're going to make that argument. And the IRS does not dispute they paid the agreed amount, but it says, hey, that offer in compromise form required you to remain in compliance for 5 years. This is such a huge issue. I know I've mentioned this in other videos, but if you want an offer in compromise, an installment agreement, other forms of relief from collection, you have to be in compliance, or the IRS can reject you without even looking at any substance of it. But then after you get the agreement, you have to remain in compliance. And we see in this case what happens if we don't remain in compliance. So this is the standard that the court uses. So the tax court reviews for an abuse of discretion where the validity of the underlying tax liability is not at issue. Almost all of these, the tax liability is not at issue. Okay, and there's some reasons for that. We won't go into it in this video, but just understand almost all tax resolution cases are not going to involve well, I don't really think I owe that money. It's going to involve I do not have the ability to pay, or it would be unfair to make me pay. And so then the court says, well, we're going to review the tax court using the same standard. So we're only looking for clear error in the facts. Okay, so the court might say, well, we might have viewed the facts a little bit differently, but we won't substitute our judgment. But now legal questions, we'll just review those and tell you what's right and what's wrong. And here's a little summary. When there's no challenge to the validity of the underlying tax liability at the CDP hearing, remember that's a collection due process hearing, we also review the officer's decision under abuse of discretion. And so if it's arbitrary, capricious, that's an abuse of discretion. So let's look. We must determine whether the settlement officer abused her discretion when she determined petitioners defaulted on the offer in compromise and sustained imposing the levy. Now here's what the petitioners say. Hey, we paid it. Actually, we paid more than we agreed to pay in the offer in compromise. But they admit that the amount that they paid did not exceed the original amount owed. Okay, so let me use my numbers just to keep them simple. If I owe 100 and they say, John, we'll take 20 from you, and I pay them 25, well, I've more than paid the amount agreed upon, but I have not paid the full 100, right? So I owed 100, we agreed to pay 20, and maybe I paid them 25, but I didn't pay them the full 100. And so here's what the taxpayers argue. Offer in compromise was not clear and unambiguous and did not properly inform them of their obligations under the agreement. And so they claim that the offer in compromise was complete, and since it was complete, it was done, it was finished, the settlement officer abused her discretion because they acted in good faith, they satisfied all the terms, they paid the amount, so why are we here? And the IRS says, hey, we agreed. They paid the amount agreed upon, but the form that they signed was clear and unambiguous. The obligation to comply with filing and payment of tax obligations for 5 years is not contingent on the payment of the amount of compromise agreement. And if you think about it, it kind of makes sense. Okay, if the obligation to pay taxes for 5 years, file your taxes, pay your taxes, was only in there when you had not made the offer in compromise payment, well, that just doesn't make any sense, because if you haven't made the offer in compromise payment, then you haven't completed the deal. So obviously you have to complete the deal in terms of paying the money, but even doing that, even paying the money, you still have to file your tax returns for 5 years. Here's sort of the theory behind it. The IRS says, look, you got in trouble, you didn't pay all your stuff, you had penalties and interest, we cut you a break, we cut you a deal. Now, we trust you've learned your lesson. Do not mess up again. See, if you mess up again, that makes us think, this is what the IRS says, that you didn't learn your lesson, and so we're going to make you pay the whole amount. And I'll just tell you from experience, people that struggle with tax issues often will repeatedly struggle with them. And so part of what we do as people who help folks that have tax issues is really try to convince them, you've got to get on the straight and narrow. If we get you this deal, whether it's an offer in compromise, an installment agreement, whatever it might be, you've got to be perfectly clean afterward. It's sort of like you have a bunch of bad debt, you file bankruptcy, you start to rebuild your credit. Well, you can't have any mistakes after bankruptcy. If you're trying to get a house in 2 or 3 years and you've got a bunch of late payments after a bankruptcy discharge, that's not going to work. So we get this great deal. Now we got to stay clean after that. So go back to the text here. According to the IRS, must comply with tax filing payment obligation for 5 years, regardless of when the amount's paid. And if they don't, then the agreement's violated. And the court says, we conclude settlement officer did not abuse her discretion when she said the offer in compromise has been violated and imposed the levy. Offer in compromise is a contract. And so we just look at general contract rules. And so here's a case from a long time ago, 1962. So what's that, 58 years ago. And they say, this is a slightly different form, But the form expressly provided the commissioner could proceed to collect the unpaid balance of the original tax liability upon taxpayer's default. This court determined the language of the agreement was so precise and the intention which it manifests was so evident as to leave no doubt that the course of action was fully authorized by the agreement. And they say, in a similar way, the offer in compromise in this case contains clear and unambiguous language that explains the consequences of the default. I mean, here's what the form says. The petitioners would file tax returns, which they did, and pay required taxes, which they did not, for the 5-year period beginning with the date of acceptance of this offer. It doesn't say, and once you pay the money, then the 5 years goes away. It's just if it's accepted on January 1st, 2020, well then for the next 5 years, you better file all your tax returns and pay all your taxes. The form further explains the taxpayers would comply with their future tax obligations and remain liable for the full amount of their tax debt till all terms and conditions of this offer have been met. And so the taxpayers concede they understood the necessity of complying with future tax obligations and what would happen. And they understood the IRS may levy or sue them to collect any amount ranging from the unpaid balance. Hence, the offer in compromise, and now they're just going to quote that Lane case, is so precise. The intention which it manifests is so evident as to leave no doubt the government's course of action is fully authorized. So, settlement officer did not abuse her discretion because the offer in compromise unambiguously explained the IRS could levy the petitioners to collect any amount between the unpaid balance and the original amount, and because the taxpayers defaulted. Therefore, the tax court made the right decision in upholding what the settlement officer did. So they affirmed that. And I've got a link down here, and I'll put this in the description. So again, the point of this case is you do an offer in compromise. That's fantastic. That's wonderful. But understand it's not over yet. Okay. So I'm recording this in early September. And, so we kind of think a little bit about football season. It's sort of like, there's 2 seconds left on the clock. You're down by 5 points. And quarterback throws the ball. The cornerback guarding the wide receiver falls down. The wide receiver's there at the 2-yard line in full stride, and the ball is right there in his hands, almost in his hands. It's like, that's great, but you still have to catch it, and you still have to get into the end zone, okay? If you drop it, then it doesn't matter how beautiful of a pass it was or how great your moves were to make the cornerback fall down. You got to catch it. Well, same thing here with an offer in compromise. You get the offer in compromise, you pay it, fantastic, that's wonderful, congratulations, but you have to stay in compliance for the next 5 years. And this is part of the reason why sometimes people who will hire somebody, like my firm, for example, to do an offer in compromise, they will pay us to sort of stay in a monitoring role where we basically get an update from the IRS if maybe we owe taxes or we miss filing something. So we can call our former client and go, hey, it looks like we missed something here. We have got to fix this because otherwise you may owe all that money that we saved you on the offer in compromise. So again, you've got to stay in compliance, and this case shows you how serious it is. I mean, it's not like these people just stopped filing tax returns or they just said, we're never paying again. They just evidently got a little bit behind. They filed their return, but they owed some money, and they thought they could just work it out, down the road. Well, the problem is they got hit with all this extra tax money. So hope you found that helpful, and I appreciate you watching this video, and I'll catch you guys in the next one. Okay, bye-bye.